The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
Can you, borrow money or have to pay on something?
If you have no credit, that's why they're going to want a third party with you.
Okay, because I tried to do that with jewelry and they wouldn't let me because I have no credit.
Yeah. So sometimes if someone agreed to pay with you, then they know they could go after you maybe, because if you don't pay, well, we'll just go after your mom or whoever agreed to pay. Or if Ashley's really nice right now and says, oh, I'll help you pay for the diamond ring that's worth $10,000. Do you get where I'm going?
Yeah.
Then you can do that. And a lot of times, I'm going to be on my son, the one that I said trash cars. My poor son, they get ripped on. He trashed 2 cars, and it was funny because, not funny, trashing the cars, but he went to go buy a car. And I looked at him, I said, okay, you've trashed 2 cars, you got to go on your own now. Like, I bought 1 car for you, it got totaled, not his fault, you know what I mean, but all that stuff. And then he ended up totaling my car. But the whole thing, I was like, you need to get the thing. So I went to the bank with him. I was willing to be a co-signer because I knew he had money. I was willing to co-sign. I have access to his account so I can see, because we're joint owners on his account, so I know when do you know what I mean? I know what he has in it. But it was interesting because it was the same thing. He had opened a credit card the year before because the bank said, let's do a checking account for you, because even though you might not have any bills, when we opened it at 17 or 18, they said as a student, being a student, it'll help build your credit. So that might be something you might want to think about, like some of the banks will do that for you. But they did that. He was paying his credit card because he got a credit card, so every month he was paying that off in full. And I'm not going to lie, I mean, probably I shouldn't whiz out his credit score and stuff, but he was in the 700s. Like, we went to do it because he was always established the credit and stuff, and all of a sudden I'm here willing to do it because I wanted to give him a cheaper interest rate. And all of a sudden the guy goes, Mom's not going to give you that much of a big break, because all it's going to do is maybe save you like $10, if even. Do you know what I mean? And all of a sudden we looked at it, and I looked at him and I said, well, I love you, but truthfully, I don't want to be on this debt with you. And since you qualified on your own, I'm not going to come on because I'm not saving you that much money. Like, had it been a difference of $100 a month bill, I would have been a cope. But the guy even looked at him and said, Joe, I wouldn't put your mom on with you because it actually could hurt your credit.
Yeah, that's what I was going to say. That'll build his credit score if you're not on there.
Right, and that's what they did. And he pays it every month, and I know he does, you know what I mean? But that's it, to build his credit. So that is one way there, if you can get something like that, if that helps you to get your credit going. And just make sure you pay your bills off. I mean, if you took that credit card and used it and then just pay it off every month, that's going to start building credit for you.
Or it's due, pay over what you, like $1 or $2 what you were owed, your minimum, or whatever.
So just little things there. I'm one that I don't like paying the interest if I don't have to. I like getting everything paid off. That's one of my probably anal things. People go, you don't like having debt out to people. I'm like, no. I do, but I hate having it, you know.
And if you pay it off up front, too, is even better. I got a credit card. I haven't raised my limit. I've had it for 2 years. It's still at $300 when I first got it. And as soon as I spend that $300 being a server, I make that in 2 days. If that, I pay it right off as soon as I get it.
Yeah.
So I don't get the interest or none of that because it's already paid off.
And some of your credit cards, like if you get your first one, hang on to it for a while. Like I have my Discover that I've had now for at least 20 years. And it has a pretty penny. I mean, I could charge on it, not that I ever would, but I just don't cancel it because I've had it for like 20, 30 years. You know what I mean?
Keep them open, it looks better on your credit.
Yeah.
They don't like to see closed accounts.
So, yeah, I was just laughing. I saw my credit score on that one. I was a little bummed. I'm like, how could I paid everything off. How do I drop 17 points? And it's funny because I was at my one level the whole way for like about 8 months, and then it's 2 periods they dropped at the same amount where it dropped, and then I'm like, yeah, next month it'll come right back up again. And I can't figure that one out, how they calculate it, but it is what it is.
They want you to spend 30% or less.
Yeah, and my problem is every time I think I pay it off more, that's when my credit score drops, when I have no debt. And I'm like, you think your credit would be really high when everything's paid off. And I just laugh on there. Questions on that so far with Daphne? There is a limitation here, though. So I told you what they can raise of defenses. There are limitations when a debtor commits fraud. Without the knowledge or participation of the creditor, will not ordinarily release the surety. Okay. the surety. There are also surety defenses. A surety can raise special defenses to avoid liability. Those defenses are the original obligation is invalid, the debtor has been discharged, the creditor allows a third party to take the place of the original debtor, or the creditor has released back to the debtor collateral that secured the debtor's performance. Remember when I made the comment, like if they said, hey, you owe 20, but we relieved them of 10, gave back 10 to them, you can't come after me then for the full amount. Do you get where we're going? That's not right. If you relieve them of the 10, then I'm relieved of that 10 too. So you have little things there. I have a couple examples here. I have Tarzan. So Tarzan happened to owe Jane $500. And it wasn't over bananas. But, so we have Tarzan. He owes Jane $500. Okay? And he gave his note for the amount to Jane. So he wrote a note to her, I will pay you $500 back, all that stuff. At the same time, an agreement is signed by Cheetah. Bless you. And it's given to Jane. And the note that was, the agreement signed by Cheetah that was given to Jane is as follows. I agree to be surety for the amount of Tarzan's note for $500. So Cheetah's coming in here and they're a surety, right? For $500 on that note. On maturity of the note, Tarzan pays $200 on the account. And then he gives a new note for $300 due in 3 months. So the original note was, I'll pay you here $500, right? But on maturity, he gives, what'd I say, $200? Okay. And gives a new note. For $300. Payable, we said, in 3 months. Cheetah is never informed about that transaction. So Cheetah originally agreed to pay what? This note off of this one. All right. The new note is not paid at maturity. So what do you think happens?
Goes back up to 5.
Jane turns around and sues on this new note against who? Cheetah. Hey, surety. Tarzan's not paying me, and this new note was due, so now you pay me. Can the surety raise a defense?
For sure. They didn't agree to that one.
Right.
What was she sue her Cheetah for, 300 or the 500?
The 300, based on the new note. But here's the problem. Did you agree to this new note? Were you aware of the new note? Do you see where we're going? You agreed to this note. You didn't even know. So here, Cheetah, when Cheetah... does Cheetah have any defense? Yes, Cheetah has a defense. And what they can do is Cheetah can raise that the contract between the principal and the creditor was materially altered without his what? Consent. You didn't tell me you were doing this. Now, if they had warned Cheetah and said, hey, we're going to make a new note and this is what it is, and now they agree to that, would that defense have held up then? No. So you get into those type of things there. And in such a case, because he had no knowledge of that, he could be discharged from liability. My other situation deals with Marie Antoinette. Marie Antoinette signs a guarantee for the benefit of her son, Louis XVII, with the Bank of France. Now, we're going to assume she wasn't beheaded, so she lived long enough to see her son and do this, right? So the guarantee includes all extensions and renewals of the son's obligations. Subsequently, a renewal of the note added an additional $600 to the original obligation. And on the son's death, the Bank of France brings suit on the guarantee, so they go after who? Marie Antoinette. The question is, who wins here? Marie or the bank? Does she have to pay on those extensions? She signed a guarantee for the benefit of her son with the Bank of France. The guarantee includes all extensions and renewals of the son's obligation. Subsequently, a renewal of the note added an additional $600 to the original obligation. Upon his default, the bank brings suit on the guarantee. Who should win?
The guarantee, because it didn't benefit her, it benefited her son.
We'll use defenses right now, though. Can she raise a defense?
Oh.
Focus on our defenses right now. Can she raise a defense? Did she consent to those additional terms of $600? Could that material alter her obligation? So here, she would raise that defense. Yeah. I mean, you could go into the other ones here, but right now I wanted you to focus on the defense. That's okay. So here's the hint. A surety will be released from liability if the original duty is materially modified to a gratuitous surety's detriment and without their consent. Because if you're going to increase anything or it's going to detriment the surety, right, where all of a sudden it originally was for $500, but now you're adding $600, they're going to be detrimented. And if they didn't consent to that, we're not going to make them liable. You should have gotten their what? Consent to do that. Any questions so far? We've talked about sureties, we talked about guarantees, right? The suretyships and the guarantees. They are different from indemnity contracts. And this is where we have to kind of look at something, because you have suretyships, guarantees, and indemnity contracts, okay? An indemnity contract is where one party for consideration agrees to pay a sum of money to another party if the person sustains a specified loss. Think insurance contracts for a minute, right? You're paying insurance, and if my car gets damaged, I'm paying premiums, and you agree to pay me what? For my loss, for that car that got injured, or my house, because the house caught on fire and I'm paying house insurance. That is different than a suretyship, because the suretyship is you're agreeing to pay the debt of another. The indemnity contract is really between like the insurance company and the person who's insuring, right? And you're agreeing to pay for their loss of something. So think of that there. Okay, so let me do Bob the Builder. Bob the Builder enters into a contract with Farmer Pickles. Whoops, wrong way. Let me switch my arrows. There you go. Farmer Pickles is not going to build the pole barn. It's Bob the Builder. Okay, so Bob the Builder enters into a contract with Farmer Pickles. He is going to build a pole barn for him. Second Bank executes a bond to protect Farmer Pickles from loss if Bob fails to construct the pole barn. So you have the bank over here, gives him what? We'll pay you for any loss if he doesn't do it. This way you don't what? Lose money, right? Bob fails to build the pole barn, and Farmer Pickles turns around and sues Second Bank, which claims that Farmer Pickles must first sue Bob the Builder. Is it correct? The question is, was Second Bank a surety? They agreed to pay him for any losses if he fails to build. Is that agreeing to pay the debt of another?
Yes.
Is it?
Oh.
Or is it more an insurance contract? It's an insurance. So did he have to go after Bob the Builder first? Or I'm sorry, did Farmer Pickles have to go after Bob the Builder first when he doesn't pay on the loss of the building? No, because it's an indemnity. You're indemnifying me for my loss. You're insuring me that if something doesn't happen, you're paying me for my loss. He's not agreeing. That's why we say that's how indemnity contracts are different than suretyships and guarantees. You're still paying somebody for something, right? It's just this is you're agreeing to pay them for a loss. And that's why I said think of like insurance.
Like car insurance.
Mm-hmm. Home insurance, car insurance, life insurance. You know, we'll get into insurance shortly. It's one of our future chapters. So there are different types of insurance, but those are indemnity contracts. You know, whether someone dies and you were the beneficiary because of their life, because maybe it was mom and dad, and unfortunately they died in a tragic car accident, and you're only like 16, but they insurance, so that way if something happened to either one of them, they were providing for their family. Do you see where we're going? They're going to pay you off on that loss then, of whatever the insurance was for. Any questions on any of this? Okay. Let's talk about letters of credits, because letters of credits are in there. And what is a letter of credit? It's an agreement between where you have one party agreeing in advance to pay drafts that were drawn by the beneficiary of the letter. So when we do our letter of credits, it's a financing agreement that enables the debtor to know how much money will be provided by the issuer of the letter of credit and the security device that assures the creditor regarding the sum of money he can legally demand from the letter of credit issuer. I know there's a couple things there where you can see an example of a letter of credit on 609. A lot of times these were done with international transactions. So a lot of times that's when you would see those things. Generally, the letter of credit will involve three parties. You'll have a payer, a beneficiary, and the issuer is the party on whom the letter of credit is drawn. It may at times involve a fourth party, which is the advising bank. And like I said, they've mainly been used in international trade. However, there is a growing use of them in the domestic sales, or where the contractor would perform on a construction contract, so like a standby letter, things like that. But a lot of times this is where you would see it in international. And you may see it here, just not as much as you would there. The letter of credit usually involves 3 contracts. So what are the contracts we're looking at? Usually we'll have an agreement between the issuer and the issuer's customer to issue the letter of credit. The letter of credit obligates the issuer to pay the beneficiary. And then the third thing would be the underlying agreement between the issuer's customer and the beneficiary that typically gives rise to the obligation that it be satisfied by payments made by the issuer. A letter of credit is actually going to be, it can be modified, but if you're gonna, you do not need consideration in order to modify it. So even though it's kind of like an agreement, you don't need the consideration there. It does need to be in writing, it does need to be signed by the issuer, and if the instrument fails to require the necessary documentary evidence, it isn't going to be a letter of credit unless it's conspicuously stated to be the letter of credit. The letter will continue for the length specified. And if you meet all these conditions on in your letter of credit and you've met them, the issuer can then must honor drafts properly drawn on the letter, or the issuer is going to be liable for breaching the contract with its customer. The issuer also has to ensure the beneficiary is given him all the required documentation before he pays on the letter of credit. If he fails to do so, he can't obtain reimbursement. And I do have one example for here, just so you can kind of see it. You are also, as the issuer, are not required to verify other matters relating to the transaction. And you can, as an issuer, get reimbursement. So we have this letter of credit. You can get reimbursement from the customer for any proper payments that you made pursuant to the letter of credit, but it can't obtain reimbursement for improper payment, payments that exceeded the amount of the letter of credit, or payments that were made after the letter of credit expired. So here is my one example, and it's a long one. So it's my Paul Bunyan. So I have Paul Bunyan enters into a contract with the Blue Ox Company for the purchase of logging. So you have Paul Bunyan. Okay. And he is actually going to purchase, and they're going to give him equipment. So we'll do that. Paul Bunyan goes and he obtains a letter of credit from Bank of Trees, a bank with its principal place of business in Quito, Exeter. That's for bankruptcy when I get to it. And what I don't finish today, I'll finish off the next class if I don't finish it off.
Okay, thank you.
You're welcome. Okay, so Paul Bunyan obtains a letter of credit from the Bank of Trees, which is a bank with its principal place of business in Quito, Exeter. The letter of credit requires that the Blue Ox submit certain documents to obtain payment. These documents were submitted through Logger Bank as correspondent Bank of Trees. However, the documents were incomplete, and Logger Bank demanded additional information as required under the letter of credit. By the time the Blue Ox got the documents to Logger Bank, more than 15 days had expired, and the letter of credit required that Blue Ox submit all documentations within 15 days of shipping the goods to obtain payment. And Blue Ox then turns around and files suit. Must Logger Bank pay? Do they have to pay on the letter of credit? So Paul Bunyan enters into a contract with Blue Ox for equipment, right, for the purchase of logging equipment. He obtains a letter of credit from Bank of Trees. So Bank of Trees over here gives him a letter of credit. So we got this agreement going, right? So people know that, hey, he might pay all that type of stuff there. The letter of credit requires that Blue Ox submit certain documents to obtain payment. So in order for you to get payment, this letter tells you you have to do certain things, and we have to get what? The documentation within 15 days. Okay, by the time Blue Ox got the documents to Logger Bank, more than 15 days has expired, and the letter of credit required that they submit all documentation within 15 days of shipping the goods. When Blue Ox files, does Logger Bank have to pay?
No.
And why not?
Because they didn't submit it in a timely, within the 15 days.
Okay, everybody agree? Additional comments? And here, no. They can't pay on the letter of credit. It can only pay according to the terms of the letter of credit. It can't comply completely with it. It must not release funds because it then has liability. And they can't waive, guess what? Time requirements of it. Any questions on this chapter so far?
So is the letter of credit considered like, is it considered a certified
It's kind
extension
of,
of credit? Like,
it's kind of like, here's a letter of credit. They'll have money. They'll have this to do
but
it.
it's not. But okay, does it have? It had to. The time has to be stated. But does the amount of credit has to be stated?
They'll, I think, list an amount to give you an idea of like
Yeah.
what they'll get and stuff. But do you see what I'm saying? It's
Yeah.
not a,
I want to know, like, if
Yeah.
I hand you a letter, like the bank, like you said,
and
the
that's
bank
why
hands
a
you
lot
letter
of them
credit.
were done in international transactions
Yeah.
because you're dealing with
Yeah,
countries
you don't know
overseas.
how
Like,
much they need.
here's our
so I'm
letter
just
of
saying,
credit to
this
tell
guy
you
has
they're
money
good.
over here,
Yep.
so
Yeah.
just let you know he's good for it. I don't
Yeah.
know how much, but whatever.
Yeah.
He's
And
good
it'll
for it.
usually say that and what we require and all that. But if you don't
But the
follow
amount
it,
doesn't have to be stated, but the time has to be stated.
they'll usually, I think, state the amount so too.
Well, we won't be tested on that.
No. I'm pretty straightforward on this letter of credits. Know who your parties are.
Okay.
Kind of like what you see in the little questions
Okay.
and in review. I don't go into depth and say, here, analyze this letter of credit for me.
Okay.
If a person writes a note to pay off any debt that another person gets into, would it only work for whatever debt they're in now or future debts also?
And I want to make sure so if you wrote a note to someone, let's just say you wrote to Tanisha, I promise to pay you $10,000 for whatever,
Yeah.
and then she does what with that note?
She gives it to like
Brad?
I think
Or
my question is dumb. I don't know.
there's no stupid question. I just want to make sure I understand what you're asking so
like,
I can.
if you have debt for to a bank or something,
Mhm.
and I give them a note and say I will pay off any debt that they get into, and I pay off the debt that you have now, but you go into debt again with that bank, would I still have to pay?
I think if you put any debt, I think it's too vague. Like in that kind, do you know what I mean? I think
Yeah.
it's, you would be signing at that time the debt that they're creating at that time.
Oh,
The
okay.
surety. Do you get where I'm going? Because you're
Yes.
agreeing to pay the debt of another, saying if they don't, I will. And usually you're doing it all at the same time.
Oh, okay.
Yeah, if that helps. Now, unless you and say Tanisha came up with something where she now says, I agree with you, hey, you owe money, I promise to pay the money for you. So you get what I'm saying? She
Yeah.
can become a surety for who though? The bank. That's kind of the thing on you, but then you'd have to, like,
Okay.
the surety is your, like that, it'd be like me knowing that you have no credit. I'm requesting a third party to come in now. Because if you don't pay, there's a chance I'm not getting my money from you. I want to make sure I get it from what? Somebody.
Yeah. Okay.
Do you get where I'm going?
Yes.
So when we enter into it, I'm bringing you in, the third party. Or if there's any doubt, if I know like you're sketchy, like let's just say I know you filed bankruptcy before, I may not want to borrow you money because of that. I might say, I want somebody to come in with you. Because that way, in case you still can't pay, I can go after who? The other part. Now, they may try and come after you for their share that they dished out. Do you see where we're going? Because now they've paid on your debt. Again, if you're bankrupt, though, they may not be able to collect, which leads us into this. I'll start it. If I do not finish, we'll see how far I get. Okay? Deal? Because I might cut it at a certain time and just say, we'll cut. So let me start us into bankruptcy. So what is bankruptcy? And you guys do not have to admit to me whether or not you've ever filed for bankruptcy. But what is bankruptcy? Bankruptcy is a statutory proceeding. So it's law creates us, right? And it allows debtors some relief from debt. And it's great. I've had people come in who have talked about bankruptcy before. Remember, like back in England, the debtors' court, you hear, oh, they're going to debtors' prison. When people couldn't pay back in England, they would throw them in prison. And people would never usually get out because they'd rot in where? Prison?
Yeah.
Bankruptcy was kind of a way to allow you to help you relieve yourself so maybe you could get back out into what? Society and relieve you of some debt here, but then make you so you're not just sitting and rotting in prison because you couldn't pay your debt. Let's try and maybe rehabilitate you, I guess you could say. So it's that statutory proceeding. It will allow the debtor some relief from debt. Now, federal district courts have authority to hear bankruptcy matters, but they have vested that authority in the bankruptcy courts. So what happens is when we talked about in D-Law 1, the court structure, you had the U.S. district courts. The bankruptcy courts are an arm. They're Article 1 courts. They're created by the legislative branch, and their judges are appointed for terms. So every 14 years, they will appoint new bankruptcy judges. They're not there for life. And just as a side, like even as attorneys, that's why I'm sworn in at U.S. Federal Court in Eastern District of Michigan. I got sworn in because I had to go do a bankruptcy matter. And you have to be sworn in that jurisdiction in order to go before the court. So again, it's not a state issue. It's always going to be heard by the federal. They handle those type of things there. Bankruptcy courts have special jurisdiction. They handle bankruptcy issues, so they're exclusive. They have exclusive jurisdiction to handle the bankruptcy matters. There are 3 forms of bankruptcy that this chapter talks about. Chapter 7, Chapter 11, and Chapter 13. There are other chapters. I will not test you on other chapters. I try to be, if I have a question and says which of the following are not bankruptcy, I try to go high enough where I hope it's not one of the bankruptcy numbers, because there is like, I think, chapter 9s and stuff like that where I might say, which of the following is not a bankruptcy, that you can file 7, 11, 13, 24. Hopefully you realize, since we didn't talk about 24, you get where I'm going? That'd be your thing there. But these are the 3 forms. So what is Chapter 7? It's liquidation. Chapter 11 is usually your business reorganizations. So like when GM and stuff like that, remember down in Detroit, filed for bankruptcy. It's, yeah, they did Chapter 11. I had to think for a minute. I'm like, but it's a business reorganization. Let's reorganize our business. Let's do that. We're not going to completely liquidate, but we want to reorg. And then Chapter 13 usually is a debt adjustment plans. Any of these are actually available to individuals and businesses. Okay? If you're farmers and stuff, you're not going to usually use these. They have separate codes. And I'll be honest, I didn't do a lot in the bankruptcy area with that there. I think I went down for this one time when I went down there, when I had to go down there. What is Chapter 7? Chapter 7 bankruptcy is a liquidation of all of the debtor's assets to pay debts. We're liquidating you. That's why sometimes you'll see people when they go into bankruptcy or they're closing, right? And then you'll see liquidated assets because maybe they filed bankruptcy. They're completely closing shop. We're going to sell all the assets and get what we can and then pay off your what? Debt. And if there's anything left over for you, you might get some or you might get what? Nothing. But we are going to liquidate all your assets so we can pay your debts, things like that. Chapter 7 proceedings are available to individuals, partnerships, and corporations. The debtor can voluntarily commence the Chapter 7 proceeding, liquidation, or creditors may involuntarily put you into bankruptcy. So you can either go voluntary bankruptcy or involuntary. It's not that I purposely wanted to go into Chapter 7, but maybe my creditors put me in there because of what I owed in debt. And we'll talk about what is that threshold there. The debtor, what'll happen here is if there's any debts remain unpaid or only partially paid, the debts will be discharged with some exceptions. Because we will look at what we can pay and some things get out. But there are some things we cannot discharge by law. And it's put into the statutory, and we'll look at that in a few. Consumer debtors may not be able to file for Chapter 7 immediately. Because what you have to first do is you have to establish that you don't have the means to pay, okay, to repay your debts before they are permitted, that Chapter 7 liquidation. So what will happen here is, what if you voluntarily file? Let's start with us. We're in a Chapter 7, and I'm the debtor right now, and I voluntarily go and I file my Chapter 7. When the debtor files for Chapter 7, you first file what is known as a schedule of current income and current expenditures. So you will tell them what money is coming in and what money you owe. And you really do not want to lie on any of this. Because the goal is to get discharged. Well, we're discharging everything. But if we don't, and I'm declared a Chapter 7, I might not be discharged from something if I don't let them know what I owe. Do you see where we're going? So we'll get into those type of things there. What happens here is the bankruptcy court can dismiss the debtor's petition if it finds the debtor didn't satisfy what is known as a means test. So you filed for Chapter 7 because that's what you want to do and you want to liquidate. Well, they might find that you don't satisfy the means test, and whoa, we're not going to let you file for 7. We don't think you should do a 7. Maybe we think you should do a what? 13. And they might deny you this and tell you to go here. Do you see where we're going? They might find you might file here and find out that, oh, you're not really this either. Maybe you're this. But if you're going to go here, you have to satisfy that means test. And if you can't, what it does is that test measures what is the debtor's ability to pay by computing the debtor's disposable income. If the debtor falls below the state's median disposable income, he will be able to continue in the Chapter 7 proceeding. But if you don't fall below that, then you have to go and you file Chapter 13. Because we don't want everybody just claiming, oh, let's do this, and you know what I mean? It's, let's see if you meet what we think there. So what is the means test? What they'll do is the means test is they'll take the debtor's current monthly income, less the allowable expenses under our bankruptcy code, which is your disposable income, and then they'll take the disposable income and times it by 20. So if you're kind of thinking of a math, you take your current income, like what's your current monthly income, then you go ahead and you deduct your disposable income. Let's say, and then what does that leave you with? Whatever's left here, you take this times 60.
Why do you multiply it?
6.
They just do this calculation. It's
Okay.
their formula, you know what I mean? So what's your current minus this to give us our disposable? I guess I should have done this.
I think it's
And this
like
comes
5 weeks in a year or something. It's like your yearly.
Yeah.
What you divide by, like what you can make.
To what would you get over this accrue?
Yeah.
Let's do
What's
this.
left
and-
over from your income or some shit and stuff.
That one.
She's in chapter 34.
34. Yeah, I kind of skipped 32. We'll do a group project next class at the beginning of class. If I don't finish this chapter, we'll finish this chapter first and then do the group project for consumer. So if you look over on page like 674, that gives you the formula too. So current debtor's current monthly income, the allowable expenses under the code, which equals your disposable income times it by 60. Now what happens here, and that's on page 674, that little thing. What happens here is the debtor will be guilty of bankruptcy abuse if the number isn't below one of two things. Okay, you either have to have 25% of your debtor's unsecured claims or 7,475, whichever is greater, or 12,475. If the bankruptcy judge finds that the debtor's lawyer acted in bad faith, they can order the debtor's lawyer to reimburse the trustee for cost and attorney fees. We'll talk about the trustee usually oversees the bankruptcy matter, the bankruptcy trustee, things like that. If the debtor is required to undergo credit counseling, you are required to actually do this within 180 days before you file bankruptcy. Because here's the other thing, before you go and file the bankruptcy, you got to think, you're going to file this and you're trying to relieve yourself of debt. What they'll do is go to credit counseling first. Let's see if we can help you out before you actually file it, because this goes on your record. It's not like you can file bankruptcy every year, but you'll have to wait a stated period of time. It used to be 7 years and stuff before you could file bankruptcy again. But we don't want people abusing the system to do what? Oh, let me just charge all this. Let me get all these TVs. Let me get these cars filed for bankruptcy, and then I'll go charge again. Do you see where we're going? So they'll try and they'll do like, first, before you file bankruptcy, go to credit counseling. And you have to do this 180 days before you go to bankruptcy, prior to you filing. You know, and a lot of times it's work out, what can you pay? What can you do on your own? Some people are willing to work out, oh, you owe us hospitals. If, say, you have medical bills and you owe the hospital, they usually tell you pay something. Even if your bill is $20,000 because of whatever services you had done, and you're supposed to pay $200 that month, send them something, because at least that shows in good faith that you're trying to what? Pay. And call them and say, you know, I'm in a financial thing. I can't afford to pay this every month. But can we make an agreement where maybe I paid this because I know I can pay this? And at least it shows that you are paying something. So if they try to enforce something against you at court, you can say, but look, in good faith, I'm really trying to pay. I just don't have the money to pay. You know, where it doesn't look like you're totally trying to get out on that. What if there's an involuntary bankruptcy? Because I said you could voluntarily put yourself into Chapter 7. Involuntary is you didn't put yourself in, it's your creditors put you in because of what you owe them in debt. The involuntary action occurs when the creditors go and file the petition with the court, and it can be commenced against individuals, partnerships, or corporations. But there's a rule here, because it's how many creditors do you have? if you have 12 or more creditors, and 3 or more of those creditors are unsecured, if they have unsecured claims that total at least 15, I want to make sure I give the right amount here because this one always changes in the books. 15,325. Yeah. So if you have unsecured claims that total at least 15,325, they can file the petition. If there are fewer than 12 creditors then one creditor has to have unsecured totaling at least that 15,325. Do you see where we're going? So if I only have 10 creditors, right, and none of my creditors hit that threshold, say the one creditor, the highest is 12,343, can I be put in involuntarily? No, because I have less than 12 creditors. That means one creditor has to have unsecured interest of at least 15,500 to even put me into the involuntary. If I have more than 12 creditors, they say if you have 3 or more, that with unsecured equals that 15. Do you see where we're going? Then they can throw you in involuntary. It's one of two ways. So it depends on how many creditors do you have. If it's 12 or more, then 3 can put you in by hitting this threshold. If it's less, okay. If there's fewer than 12, then one creditor with that unsecured claim can put you in. Because they're putting you in. You're not asking to go in. They're kind of forcing you to go into what? Because they're saying, you have too much debt. We're going to throw you in because of what you owe all of us. Type thing there. The debtor may contest this petition, but if he doesn't file a petition, the court will then enter an order of relief as long as one of 2 grounds exist. So the grounds are either that the debtor is generally not paying their debts as they become due, or within 120 days before filing of the petition, the custodian has been appointed for the debtor's property. Now, what will happen is once you do go into Chapter 7, whether it's voluntary petition or say the involuntary, once we're in there and we're starting, you then get into what is you're entitled to an automatic stay. So I voluntarily put myself in. I know I can't pay my debts. I need to get some relief. I'm going to go ahead and file for petition for bankruptcy. Once I do that, they'll put an automatic stay in place, which means that actually creditors, you can't take action against me. You need to stop calling me. You need to stop hounding me because guess what? I'm going into bankruptcy and I'm giving you notice and we're going to prevent you now from what? Kind of harassing and stuff, but we're going to put a stay on the creditors. It's an automatic stay. And you can't take action against me. It'll end once the bankruptcy matter is finished, dismissed, or when the debtor is granted a discharge. So it's kind of like, hey, we're all in bankruptcy. Now let's play it through the system and see what you get. You know.
Are you talking about Chapter 11, bankruptcy?
Chapter 7.
Oh, okay.
Yeah, 11 I'm very short on. We'll talk about that at the end. 11 and 13. So when we are doing this, in involuntary bankruptcy proceedings, the stay is going to be lifted in the event the petition is dismissed. If you look over really fast on figure 34-1 on page 678, that right there kind of gives you charts of 7, 11, 13. It tells you who's eligible, voluntary, involuntary, what happens. It tells you the numbers, you know, what you need and how many to put you into it. So it kind of lays it out. And you can tell that 7 and 11 are very similar in a lot of things. They might have a few differences, but do you see how they're kind of similar? For their numbers on requirements for involuntary and voluntary might be a little different. You both have to satisfy the means test there. If the matter involves a consumer case, we also have a test for eligibility. Now, upon commencement of the case, they will appoint a bankruptcy trustee. That's who's going to oversee it. So what does the trustee oversees? He administers the bankruptcy estate. In addition, the trustee has the right to gather the debtor's property. He has the right to determine the validity of the claims. The trustee can also set aside transfers that were made during the period leading up to the bankruptcy if he finds that the transfers were or security interests were made to give preference to certain creditors. We'll talk about that shortly. That's voidable transfers. Because maybe you gave somebody something that they wouldn't have gotten in bankruptcy, but you tried to what? Favor that creditor knowing you were going to file for what? Bankruptcy. So let's just say I owe you $12,000, but if I file for bankruptcy because it's unsecured, you might not collect. Where you may be secured and you would take, but what do? I give you your $12,000 and then I go and file what?
bankruptcy.
Do you see where we're going? That trustee could set that aside on me and say that was avoidable transfer because you did it to what? Favor one creditor over the other, knowing you were going to go into bankruptcy. So there are those type of things there. So he can set it aside or void. Transfers by the debtor that the creditor holding a valid claim under state law could have avoided at the commencement of the bankruptcy case, and statutory liens that became effective against the debtor at the commencement of the bankruptcy. If you look at page 680, that kind of takes you through the whole step of the bankruptcy, and we'll kind of finish up and go through all that there. And I just want to kind of go back to 679 for a second. Did you guys read all the people you look at who have filed bankruptcy, and you go, oh my gosh, I would have never known these people are worth millions? You get people like Michael Vick, MC Hammer. You would probably look and go, really?
Walt Disney.
Walt Disney. That's what I'm saying. When you see some of this, and sometimes they do it because they need to reorg, because maybe they're a little more in the red than the black, and they just need to maybe trim stuff down. So we get into those things here. I'm going to stop at voidable preferences. We'll pick up their next class, and we'll continue, and then we'll just go into the next thing there. Before I do, though, I'll let you guys go. I just want to hand this out now.
Good luck with today's lesson.